Good morning, Chair, members of the committee. My name is Marter, and I'm the Deputy Prosecutor at the Prosecutor's Office. I've been there 20 years. My position at the Prosecutor's Office for the last 8 years has been the Chief of the White Collar Crime Unit, and we prosecute all of the computer crime cases that are generated here on Oahu. I've personally done over 100 of them, and many of them investigated by HPD. I first want to apologize to the committee. I haven't had an opportunity to prepare written testimony. I heard about this hearing late yesterday afternoon, but I will give written testimony to the committee by close of business today, and I hope that the committee will forgive me and make that part of the record. We're here today, the Honolulu Prosecutor's Office, in strong support of this bill. And I want to start off by addressing some of the comments that I've heard just in the last couple of minutes. First comment, that this is an unconstitutional bill. That comment was made by 2 people. Now, the committee may or may not know that most internet service providers and most cell phone providers are already retaining data. For example, IP logs. I could issue a subpoena or a court order to a service provider, and I could obtain somebody's internet history right now. So for the people that say that this bill is unconstitutional, in effect, basically what they're saying is that the practice of the internet service providers and cell phone providers, what they're doing right now, they're violating people's constitutional rights. And that is unequivocally false. The reality is that service providers are already retaining records, sometimes for as long as 2 years for certain categories of information. And I think it's real important for everyone to understand that this bill will not give the government free access to records that are being retained. This bill does not change the laws that are in place right now that require law enforcement to meet very high legal thresholds to obtain records. For example, in Hawaii, we can't obtain IP logs or cell site data, that sort of transactional data, without a court order, and we have to establish to a judge probable cause. This bill's not going to change the legal requirements that we're already operating under right now. It's not going to change the fact that providers right now are already retaining data. What this bill hopefully will accomplish is to make sure that that data is available to law enforcement if and when someone becomes the victim of a cybercrime or other types of crimes, because we're seeing the technology is involved in more and more types of criminal activity. So the purpose of this bill is simply to impose upon the service providers the requirement that they retain that which they are already retaining. Now, some are better at retaining it than others. There are a few cell phone providers that won't even retain a text message for a single day. Some won't even keep cell site data or IP logs for 60 days. And the problem for law enforcement is when victims report that they've been the victim of a cybercrime, such as an unlawful intrusion and their data's been stolen and compromised and used for unlawful purposes, by the time law enforcement gets that report and identifies the provider and generates the legal process that we're required to obtain that data, the provider tells us that data's gone. And that's the end of the case. And everyone in this room is aware of the problems of cybercrime. It's in the news almost every day. We've had many high-profile instances here on Oahu where residents of Oahu have been targeted by cybercrime. And if we can't even access the data that would lead us to the suspect, there will be no prosecution, there will be no accountability, the laws don't get enforced. And in our experience, in probably 25% of the cases, when we serve a subpoena or a court order or search warrant on a provider, they tell us that data is gone. And so I think it's real important to understand that. Now, one of the things that was mentioned was that there's going to be a quote-unquote flood of requests by civil litigants to obtain data. And so somehow if this bill is passed, that the floodgates are open to the civil litigants and it'll be abused and there'll be all these problems and how are the providers going to comply? Well, the reality is under the law, there's nothing to prevent a civil litigant or a civil lawyer to make a request to obtain access to this information. This bill isn't going to change the fact that those civil litigants already have that legal right to obtain access to it. The standards are going to be different, what they have to comply with and what law enforcement has to comply with. But the fact that this bill is adopted, it's not going to open up the floodgates and all of a sudden civil litigants are now going to start flooding the providers with these requests. They can do that now if it's relevant, and there are legal rules in place for them and the service provider to comply with them. The courts oftentimes will get involved and resolve it. But it's not, in our view, a genuine argument in opposition to this bill. The unconstitutional argument, that argument is just flat out wrong. The comment that this is an overreach by government, you know, the reality is that there is a pending bill before Congress right now. And if you look at that bill, and I have a copy of it right here, I think somebody mentioned it, it's HR 1981. That federal bill is almost exactly like this bill. They both require the providers to retain IP logs. That's it. No one is saying in this state bill, or even in the federal bill, that the providers retain email, text messages, voicemail, that sort of thing. No content is going to be affected by this bill or even the federal bill. It's just IP logs. And the reality is they're already keeping it for some period of time, most of them. So again, the purpose of this bill is just to make sure that it's available to law enforcement, because the reality is the general public expects government to provide some degree of protection and public safety. And in fulfilling that responsibility, law enforcement has to take the complaint and investigate the complaint. And if it comes to a dead end because the provider hasn't retained the records, then what have we done to protect that victim or future victims from cyber criminals? The other thing, this argument about privacy. There's a lot of people out there that are committing cybercrime, these unlawful intrusion cases, where they're penetrating systems and stealing data. And if law enforcement investigates those cases, and we go back to the provider, say Roadrunner, we want to know who was assigned to this IP address on the date and time this system was penetrated, and they tell us, sorry, we don't retain IP logs for more than 2 weeks or 1 week. Well, the people whose privacy has been violated and whose data has been stolen, what protection have they obtained? Nothing. So I think there has to be some balance between privacy and the government's right to investigate these complaints and hold people accountable. The other thing too is the idea that imposing a retention requirement on service providers is going to expose the general public to greater threats. That's not a valid argument. Look, the reality is the providers have legal requirements and obligations to protect people's data, including their IP logs. And that's written in both state and federal statute. They're required to protect that data. So the argument is, well, a hacker might all of a sudden now want to penetrate Roadrunner's server and get the IP logs of, so-and-so. They can do that now. The question is, how far back can they go now? This bill would basically require them to retain it for 2 years, but the reality is the providers are going to provide protection for their customers. And if they don't, they're going to report that and they're going to take steps to lessen the damage. So I don't think that's a valid argument that somehow retaining it is going to expose more people. That's just simply not true.
So
what argument
we're going to have to have you summarize here a little bit. So
okay. Well, the last issue about cost. Yes, this will add some additional cost, but I don't think the industry can dispute the fact that storage costs have gone down exponentially over the last 5 or 10 years. So storage is not a justification for not having this bill. Again, I think it's important to remember that government's not going to have access to the data unless they comply with very strict legal requirements. And if they do, they should be able to access it for that very limited purpose of investigating a reported crime. If we don't have access to this, a lot of cases simply won't get investigated or prosecuted. So we believe that this is fair and reasonable. It's consistent with the federal statute, only addressing IP logs, not content, and that that's a fair balance. And we believe also that the committee does have some room. You know, we require banks to keep records for 5 years. They're able to manage that. And so are credit unions and savings and loans, and so are credit card issuers. They can retain records under federal law. Lawyers and a lot of other professions are required to keep records, so service providers can do it too. Thank you very much for the opportunity.